everybody. I hope you can hear me. I appreciate your patience here and a little delay on my part. I'm actually in training today, so I've scabbed up from the training to join you. What I wanted to do is show you a video. It'd be the first time I've actually been able to do it through my laptop, so I hope it works well. It's called the Dementia Experience, Walk a Moment in My Shoes. And give you a little insight, and I'm quite confident that you folks probably experience these type of situations on a very a daily basis. But the idea behind it was to educate primarily police officers, but also the general public to whom we showed this video to. And just an aside, it's that since it was produced, it's been shown around the world, which is kind of cool. And the idea behind it, and I think we could extend that thought beyond just the whole issue of dementia and the diseases that come under it. I think brain injury could probably be very much an extension of that, because I only imagine that people with a brain injury would probably be in the same type of situation of the two people that you're about to meet. And I want to show it to you, and then if you like it, you find it of value, you're more than it's there, you can use it. I have all the necessary disclosures from both the individuals and their family. And there's a PowerPoint that was developed to support that from a training perspective. So I'm going to try to share my screen, and if my fingers cross correctly, again, that being fingers crossed, can you see something that says a dementia experience? Looks like a TV screen right now. I see a head nod. Awesome. All right. Now, if I can figure out full screen. Ooh, look at that. I scare myself sometimes. It's somewhat depressing, but I don't think it'll be surprising to you folks, because it's probably something that you deal with all the time. So I thought of a bit of an intro, a bit of a downer, if you would, and then from there we'll build hopefully up and different approaches. And we're going to continue from what we talked about last time, and I'll give you some more information with respect to the issues related to power of attorney, of course, and wills, if this works. So I hope you probably experienced that a lot, obviously more than I would as a police officer. But I'd like to challenge those who are here with us to, my apologies. I'd like to challenge you to realize that as policing, we're not accustomed to seeing these types of situations. And although may it be dementia, or may it be some other form, brain injury, for example, I'd like to challenge you to reach out to your local police service. Let them know you're out there, because I can tell you a lot of people do not know that you're out there, and make a connection with them in hopes that you're able to help educate us on how to deal with these folks, because this is what we're dealing with now and then. And of course, you're dealing with it on a daily basis. So are there any comments anybody wants to make about that video as I'm just setting up the PowerPoint? Have I still got everybody with me? I hope I haven't scared anybody away.
Hi, it's Julie from the Brain Injury in Sudbury.
Hi, Julie.
Hi. I know it's Thursday, whatever, but this was great. I'm sorry, but I cried.
Don't be sorry. I did too. I do every time I hear it.
The two gentlemen that spoke, along with the one gentleman's wife, that's exactly what we go through, because I'm a survivor of brain injury. That's what we go through time and time again. Right? Because they think we're drunk, whatever, or we look normal, but we're not anymore.
Yeah, and no fault of yours whatsoever.
No.
Yeah, yeah. But and from my perspective as a police officer, the challenge is you look normal, you appear normal. There is no indices to me other than maybe your actions that would ever suggest to me anything other than that. So generally speaking, and I can tell you, I learned a lot. I was sitting, you don't see me in the camera there, of course, it was deliberate. I was sitting in that room, and it was hard to take. And every time I play this, it is hard for me to take. But we need the support of your organization and organizations like yours, Alzheimer's Society, even when it comes to dealing for people with hearing challenges, etc. And that's why I think it's just so great that Ruth has been able to set that connection up with us. I'm going to continue to pitch that. But I challenge you as an organization across Ontario, Sudbury, Mississauga, Ottawa, right into the Northern Tundra areas, reach out to your police services, because they don't know you're there. So they probably never going to reach to you, and help us understand what we're up against. And then maybe together we can figure out better ways of, so we don't look at you as somebody evil. We don't mistreat you and naturally assume that you're high or drunk or whatever the case may be. So,
Martin, if I can just say, it's Ruth, I just want to say I'm just very grateful for your dedication and for your passion about vulnerable persons and the interactions with police, because I think I can speak on behalf of most of the associations here. We all know of members who have had interactions with the police that have not gone well. And there's just a lack of knowledge and knowing, and like we get that, but I think your passion and the group that you've brought together with Leaps is just so important. And I'm just really moved by your own passion and dedication, and certainly look forward to working with Leaps with you and the group.
Thank you, Ruth. I envision, and I throw that out to, again, maybe a second challenge to you, if I'm even allowed to challenge you, but the second one was maybe somewhere along the line, using the resources that we have, this awesome videographer that we have. And maybe if you have a client or somebody that is prepared to sit in front of a camera and explain to us what went wrong, and then give us insight on where to go to learn from this. As I said, that video that you just watched has been shown, part of it, the first part with David, has been shown around the world as part of the brain injury, frontal temporal, research that was done to UFT, and it's actually on their website, that David portion. So we're getting the exposure, and I'm doing everything I can to get the exposure across the province. So if you can think of something, and if somebody's prepared, I will do my darndest to make it happen.
That's amazing.
I just want to add in, sorry, Ruth, I don't want to interrupt.
Oh, go ahead, Melissa.
I was just going to say, we are part of the Toronto Police Beyond Disabilities Consultative Committee. And we've also put together a video, well, they put it together, but we do have someone with lived experience in it, and it focuses on interactions with the police for persons with invisible disabilities. So it looks at mental health, autism, brain injury, and so forth. So I don't know if you've seen it, but I can share it in the link if anyone's interested in having a look.
That's an awesome video. I personally have seen it, Melissa. Thank you. Yeah, and I just kind of straight. I know it's a bit of a downer start here for a presentation, but I thought maybe it was an opportunity to put that challenge out. And Toronto saw the need. I will definitely tell you the need is there. It's a need that's not only provincial. Let's get even smaller in your area. Definitely provincial, nationally and internationally, because we've got to stop looking at people by the perceived disabilities and all their abilities instead. And those interactions, they're not going to go away. You know, Howie's wandering down the street. He lives in the city of Oshawa. Ooh, well, the city of Oshawa is 200,000 people. You know, like now as a policeman, my challenge is, how do I take care of Howie? You know, and if that interaction can be built through folks like you, your local organization, and ways of making that much better, please do. Anybody else? Hi, Russ.
Hi, Martin. If I can just interrupt, I don't know if you guys can see this or not. As a police officer, are you aware of the OBIA survivor card?
I was sent a card most recently from that I believe was more of an international. I am waiting for someone to send me the OBIA because interesting enough, when I got the previous one that was sent to me, I sent it out through Leaps, and within 24 hours, I got a response from officers up in North Bay, and then we connected the North Bay officers with the North Bay. I don't know if you call them districts office, so that they can get some training kicked off. And I want it. So if somebody's prepared to send me a copy of that, that would be most awesome. I'd really appreciate to see that.
Yeah, Martin, I will send you a copy, and we're also looking at something I'd like to bring up at our Leaps next Leaps meeting. That's something percolating.
Awesome. Great. That's the 1st of December at 10 o'clock.
Yeah.
Thanks, Russ. At one point,
The only reason I bring it up is because I was in an accident, a second car accident, and I was making no sense whatsoever. The officer found that in my wallet, and then all of a sudden I was in an ambulance with the head restraints, and it gave him the information that there might be something really wrong here.
Okay. And was that a positive experience or negative?
Yes, positive, absolutely positive.
Awesome. Thank you. I'm glad to hear that. The one concern I have, and I think that these identities are great. I wear a medical alert now and then when I remember to put it on. The problem with the cards is a little story for you with David and his frontal temporal. And again, David is far from what I learned was non-traditional dementia, Alzheimer's sufferer, if you would, right? Because like he said, we expect to see the grandmother type scenario. And his wife had indicated that they'd be in the grocery store the day before, and he started to act out. He just started to dance in the aisle because that's, I guess, what he does. So I asked him, I said, if a police officer was to respond to, because the grocery store now thinks that you're high or you're really disruptive or you're a threat to the community, what would you do? And he said, well, I would reach my wallet. Now, unfortunately, that's not a comfortable situation for police. So I'm wondering if there may be, and again, I just throw that out for whatever value it is there another way to identify, such as maybe the medical alert, or maybe something inside the coat kind of deal, so that you're not reaching, because as a police officer, when we walk into a situation, we don't know what's happening, and then we have people reaching for things. Right. The level of uncomfort is there. I'm glad in your case, he found it in your wallet while looking for your driver's license. That's awesome. But just a thought, I just tossed that out there, Ruth.
Yeah, thank you.
I just tossed it out there. So ultimately, definitely the label across the head would never be a suggestion, but maybe an extension of the medical alert might be a consideration. And then we educate people. I'm sure you're aware Alzheimer's, it is in blue, the medical alert, versus the red. I can tell you a lot of police officers do not realize that the blue exists. So again, we're making that a mission to try to educate people on that. But just a point. And Russ, thank you very kindly for that, sir. Is there anybody else who wish to comment on that video or anything? If you see value in it, you want it, it's yours. Let me know.
I just wanted to share something. We've had a very positive relationship with the Niagara Regional Police. I'm not going to get into a lot of detail, but I had a concern regarding one of our participants who was experiencing some progressive dementia. And I had some safety concerns, even though allegedly he was in a secure place. But I phoned and I gave them details and my rationale as to why I was concerned. And the police did investigate. And of course, they came to see me and they went to where he was as well. And about 2 weeks after that, they found him wandering on the street. I'm not going to go into detail about why or where he was trying to go, but he was completely disoriented and lost. And had they not had that communication with us previously, they would have had a difficulty trying to identify him. and get a bit of background and history. And as it turns out, working with Bayan and working in liaison with the Niagara region, because I had been working previously with them on this case, the detective was able to get him placed in a secure facility.
Nice. By chance, were you working with Michael Payne?
No, that wasn't the individual.
Okay, so okay, he's the vulnerable persons officer. Would be a good person to connect to as well. He's just
I was working with a detective.
Yeah, but Michael's in the vulnerable persons unit, just to let you know. And I can send you the connection if you just email me. I can send that to you.
Okay, thank
But
you.
see how important that relationship is? So all of a sudden it came from a wandering soul. What am I going to do? Oh my gosh, who is he? How do I find them? Resource to, hey, we know who he is. We know a little bit of background. He's not drunk. He's not stoned. He's not stupid. He's not deaf. You know, all those other things that were expressed. So, yeah, I know I kind of digressed a little from the program for today, but I wanted to put that in as an opportunity. So those relationships, folks, are so important. I thank you for your thoughts. Was there anybody else that? Okay. Was there anybody that wanted to, any questions from last week at all? Oh, sorry, last session. Any questions came out of that? Again, I will always challenge you to stop saying power of attorney. Funny enough, I actually heard it yesterday when we were filming on Zoom or TV. The lawyer that was there actually used the word power of attorney. And I lecture her all the time not to do that. POA, no. And again, from a technical perspective, there's a reason for it because of legalities. There's no such thing. It's paper versus human. But what it does is takes away that power of one person's perception over another. Whether it's perceived, whether it's practiced or otherwise, you take that away and throw in the fact that it's all about responsibility. And in your case with your clients, responsibility, I can only imagine, is quite heavily harsh, challenging at times, because I imagine that some of your clients are going to be similar to a David type situation. Is that fair? Okay. You know, visually there's nothing wrong with them, but they're not the traditional 85, 90-year-old. And by the way, the age of never should be a determining factor to vulnerability. And of course, a brain injury can happen to anybody at any stage of their life, right? Definitely not an age perspective. So some things we just flipped through some things today. One thing I did want to talk to you, spend some time on, is the actual power attorney document for personal care. You're probably all quite familiar with it, but there's a lot of misconceptions around it. For example, the use of, when it's not there, the use of a substitute decision maker outside a medical institution. Be careful, because it's intended for within the health structure. And I realize you're a part of that structure. So are there any questions from the last one? No, I'm too fast on my fingers here. Anything at all? Any comments?
Not really. The only thing I wanted to reach out for was maybe the documents that you said there was like a three-page document or a few documents that we could go to find online to make sure that we were assisting people to fill out the correct ones.
Okay. Yeah, what we can do is, if you'd like, I can send you in Word format a number of documents. I can send you what a general.
Yeah.
So they just have to type in. I can send you power attorney, continuing power attorney for property, and it's got some revisions. Remember, it can be in any form. So I've added things in it to protect people, like initials on every page, little indicators to remind people to do that. So I can send that to you. Yes, definitely. I'll send it out through Ruth and Lauren, and I'll make sure that it's available to them.
Awesome.
If
Thank you.
I also like to offer to you, if you want it, is there's have a multi-page document that I received when I did my training in Osgood that is a responsibility of an executor. I don't know if you have that situation. People are wondering what they're up against and what their duties are. I have some documentation on responsibilities as an attorney that you're more than welcome to as well. And there's a sheet that I put together that one side talks about what the grantor, the person to whom the document is about, must know before they sign it. And then the other side, the flip side, talks about the responsibilities of the attorney. I can send that to you in Word, and you're more than welcome to put your particular title on top of that. Take away the Durham Regional Police and put your title. Feel free to do that if that works for you as well. So I'll make all those available to you through the Ontario office over the next couple of days.
Martin, it's Dave Gaylor from Hamilton. I was just wondering what you mentioned, a vulnerable persons unit. And I was wondering how many police forces have a vulnerable persons unit.
Very good question. And I'll tell you, very few do. Hamilton was basically the kicker for the province and became the model initially. We have, most police services have what we call a vulnerable coordinator, if you would, as opposed to a true unit. And so we don't have we have a unit, but it is currently a sergeant and working in collaboration with a social worker with geriatric experience. But they are basically more reactive. They don't investigate. They don't. They field calls. If the need be, they will go out and visit people. And because we're connected to the social worker, who is a regional municipality Durham employee, not a police employee, and a healthcare professional, that individual has the ability to speak to the healthcare profession, as you folks know, relative to privacy issues, and they have that much more flexibility available. They have access to all the social networks as well. I'm trying to revise it so that the unit building on that becomes investigative as well. But it's not a big thing in Ontario, unfortunately, currently. I did do a pitch to the government going back 2 years ago, 99, to the Solgen. They liked it, the idea, and what it was it was going to force organizations, police services to organize themselves better, keep statistics, and they got derailed by other priorities, unfortunately. I'm still pushing for it because we do have to get better at what we're doing. And we need to work. We cannot do this alone. Police realize that. We need the support of you folks and others. So what a long way to answer a simple question, eh?
Thank you.
So to answer to your question, there are probably actual vulnerable persons units that are complete. I would say 1, Hamilton. Versions of it, 4, Toronto, York, Durham, and Ottawa, unfortunately. So
Thank you.
you're welcome. So again, when it comes to these documents, may it be a power of attorney for personal care, maybe continuing power of attorney for property, and for that matter, maybe even a general, and definitely last, a will and testament. It's all about people's wishes. And the more your clients, and in your personal needs, by the way, the clarity that you provide in those wishes, take the time to think it through, take the time to express what you mean. Don't leave it to interpretation. If the power of attorney document says, when I am deemed incapable in accordance with the Substitute Decisions Act, that triggers or should be triggering a capacity assessment. And I would imagine a lot of your clients have already had capacity assessments for varying reasons done by people with more experience than capacity assessors. Again, I'm not trying to degrade the system, but I would imagine that your clients work with psychiatrists and specialists in brain related issues. So You know, those documents, that trigger mechanism needs to be there, some control mechanisms, because if they don't, unfortunately, they're opening themselves up. The challenge I would imagine for your folks, your clients, would be if they've had a predetermined brain injury or cognitive concern, do they have the testimonial capacity to enter into these documents? And is that going to create challenges at a later point? And it's difficult, but it is achievable, by the way, because just because somebody has a brain injury doesn't mean they can't formulate a thought process, cannot express their wishes and their desires. Again, you would know this much better than I would ever do, and come up with a choice. It might take a little more effort, probably some patience along the way to get that from them. But at the end of the day, they're no different than anybody else, and their wishes can be. To protect the document, though, if it's done before a lawyer, that information needs to be expressed to the lawyer at the beginning. And then the lawyer needs to take appropriate steps to protect not only their integrity as a professional, but also the individual's documents that are created, to say that at the time they had the capacity that is required to complete these documents, to ensure that their wishes were put there. But hiding that from somebody such as a lawyer at this time is a very, very dangerous practice, and it could eventually lead to those documents not being accepted, and ultimately their wishes not being accepted. So just a quick overview again for all those documents: power of attorney, of which there are 3, and the last one, testament, resident of Ontario, cognitively aware, possibly a challenge here. It can be any form, but it must be titled appropriately. Take note of those titles, folks, because in your world, I'm sure you have had them presented to you before. I can tell you that there are a lot of documents out there that aren't worth the ink that they're on, because the first line that is presented to them is wrong. It's not within what the law says the title is supposed to be. You can't see the slides. My apologies. I'm so bad. Thank you for telling me. Can you see them now? I'm so sorry, folks.
Yes, we can. Yeah, thank you.
Okay, thank you. And thanks for telling me there. I'm so sorry. Again, I will send these slides on through the Ontario office for distribution, and use them as much as you want and value. Hopefully it's there for you. And just an aside, I have one put together on last wills and testaments. If you see a need for that, I can send it off to you as well. I'll just send it, and if you need it, get it from the Ontario office. So those titles are very important. So if you have someone, and something I see all the time is that, and I experienced it myself, because when I started as a police officer, I made sure my will was done, my power of attorney document was done. And when I started doing this stuff, I went back and looked at my power of attorney document, and the title's wrong. And now it was done by a lawyer that's practiced for many, many years. He's since retired, but he called it a continuing general power of attorney. You'll notice there is no title such as the continuing general power of attorney. It doesn't exist. I don't know where he got it from. And how many clients did he have that he produced this document for? So if it doesn't exist, how can anybody respect that document and action it? Problematic for me, because I ended up having to go get it done again. If you ever come across enduring power of attorney, by the way, that is a BC form. It is not, unless you're dealing with a client who happens to have an address in BC, a permanent address in BC, is not a document you should be working off of, because it's not legal in the province of Ontario. It's a BC document. So it has to be the full legal name. So if your client is Howie, Howie's not his name. His name was Harold. I forget his middle name, but Harold. So what if you're dealing with these documents and your client asks you about that, make sure that they're using their full legal name according to the birth certificate. And if they're known by a name such as Howie, in brackets behind their name, they can go also known as Howie. So that they can make a direct relationship to the fact that that's the guy everybody knows. It's Howie. It has to be dated. It must be signed by the individual. That's why it says you. And key in there, witnessed by two people. Very, very important too. I have one recently produced in front of me from a long-term care resident. The director of the long-term care facility presented and said, well, this is the document, the POA affirmation, and it actually affirmed a will. So my response was, did you read this? Because they've been acting upon this. It wasn't even an actionable document. And then when I did look at the continuing power of attorney, it wasn't even signed. So of course, my most appropriate answer was, I hope you're not acting upon this. So in your particular case, when you're looking at your power of attorney for personal care document, for example, make sure there's a signature on there. And when that's a protection mode for you, of course, because if it's determined later that you were taking action, power of attorney for personal care, and it's not even signed, it's not a legal document, it doesn't exist. And something that a lot of people do not understand from a witness perspective on your power of attorney and your last will and testament, they are not attesting to the content. They're attesting to the fact that you were before them at the time of the signature. They observed you put pen to paper, i.e. signed before them, and that you did of your own free will, that you appeared to be cognitively aware, and that nobody was forcing you to do so. So that's extremely important, because a lot of people think that the witness is attesting the content. No. So they should always be strangers, and they cannot be somebody named in the document, and they should not be anybody in bloodline, because in the case of a will, they can't be a benefactor as well. So again, the three types. I already said about the nature of the title. First one, general, physical. I would imagine in most cases for you folks, if there's an impairment that affects cognitivity, general power of attorney might not be appropriate. Continued power of attorney for property would be more appropriate. Always remember, it's the world of wishes and then the term. Is there any concern, any questions about that quick little overview there? Anything
Hi,
anybody
Martin. It's Julie from
Yes, Julie.
Sudbury again.
Yeah.
Okay. After the last session, which was great, I took out my stuff, right? The will and the power of attorney and the power of attorney, continuing power of attorney. Okay. It was done 8 years ago. Does it have to be, because this is 8 years later, the power of attorney, personal care, mine doesn't say that. It just says continuing power of attorney.
Okay, so you and there's two questions in there that I'll draw from that. First and foremost, time does not expire your documents. The only one that would be expired is if you did a general power of attorney, because you must put a time limit in there, you know,
Okay.
between this date. So in your case, you don't have that. But when it comes down to power of attorney for personal care or continuing power of attorney for property, I could have written it 20 years ago and it still would be good today unless I wrote another. And then, of course, on signature of the new one, it invalidates the previous one. Same holds true for will. But in your case, is you have a continuing power of attorney for properties. So you've got a document that covers you off if you become mentally incapable, if that's what your document speaks to, probably around paragraph 3 or 4.
Yes.
And it's strictly for property. It does not cover healthcare.
Okay.
So you should have another document out there that says power of attorney for personal care.
Okay, so both of mine say continuing power of attorney, but reading it, one's for property and the other one is for personal care, but it doesn't specify that in the heading.
Correct. So the second one, the one that talks about personal care, but is titled continuing, doesn't exist.
It doesn't exist.
And there's no such beast.
Okay, even though this was done 8 years ago.
Again, the same problem I'm having with a lot of times with lawyers. I have
Okay,
a
no,
binder that is 2 inches thick of documents done by lawyers that aren't worth the ink that they're written on, because they have failed to have done the basic thing. So personal care, now back to here, power attorney for personal care. That is the title. If you can see the arrow moving,
Yeah.
it must say power attorney for personal care, and then it speaks to personal care. Okay.
Okay, so
The
basically
continuing,
it should be redone then.
well, not redone, it should be done.
It should be done because it wasn't done correctly the first time.
Yeah, you don't have anything right now.
Oh, I don't have anything right now. Okay, no, okay.
Again, you don't have for personal care. You do for
Okay.
continuing power attorney for property. So your property component is taken care of for you, which is cool. Because that's the assistance in managing your banking, your actual property, your car, your house, that kind of thing. But when it comes to personal care, if you remember, there's the 6 categories of personal care.
Yes.
Yeah, so that's what you're looking to cover off.
Okay.
Okay, and that's what you need that other one for. Now, just so you understand, some people go, why do we call it continuing power of attorney for property versus a power of attorney for personal care? So what happens in the simplest form, a general power of attorney, if you remember, is for physical, not mental capacity, and it ceases to be in place when a person is cognitively impaired. So that knocks the general out. So cognitive issue, general no longer. The continuing power of attorney, the reason they use the word continuing is that I signed it, I authorized it today. I am of right mind. Some people might dispute that, but I'm of right mind when I signed it. And it just sits there. It's a legal document, but it's just there for the next 20, 30 years until such time as I need to use it. And then if I become incapable mentally, it's still a legal document. It is not invalidated by the fact I become incapable. The difference, and one that, again, back to, I assume the one that you folks would most deal with is the power of attorney for personal care. What happens there, and which we will get into, actually, I'll hang on to that just for a second. Yeah, let's dissect that, because the property one isn't so important to you. I was going to do that for you, but let's talk about personal care here. So personal care has the 6 categories. And what most people think is exactly the same as a continuing power of attorney. And in the fact that when capacity is lost, it's always in play. And that is not true. Unless there is proof and evidence of the fact that the person is no longer capable, i.e. they've been deemed incapable of making decisions, personal care, by a certified capacity assessor or a medical professional, not a JP who would express an opinion. So the whole point in personal care is that it's trigger based. So what happens with it is it's good today as a document, but it's not in place because everything's cool. But I know that next week I'm going to have an operation. And during that time, obviously I'm going to be put under, I'm going to be under medication. Nature of my operation is going to cause me to be under medication, and the influence of medication probably for, let's say, a couple of weeks before I will get clarity of mind back. So during that time frame, the power of attorney for personal care will kick in, and the attorney, if necessary, will be available to the medical people to make decisions on behalf of the grantor, on my behalf. 2 weeks from now, all things are good. I'm physically healing. It's a process, yes, but I've got clarity of mind. Then the power of attorney for personal care is not supposed to be in play anymore. it goes back on the shelf. 2 years from now, they need a follow-up operation. Same type of thing. I'm going to be under for a little while, medicated for a little while. And during that period of time, the power of attorney document now kicks back in. It's not a new document, it's the same one that I have today, but it's back in play. And then the moment I have clarity of mind, it's back on the shelf. Does that make sense? I hope it does. And it's one of the biggest things that's misunderstood in when it comes to power of attorney for personal care. People think that once you start talking, you continue to talk on behalf of that person. The other thing that's very, very important when it comes to power of attorney for personal care, and I'm sure, again, an assumption on my part, that you folks come across it though. And what that is that the attorney will step forward and say, you know, I'm here to speak on behalf of my, let's say, mother, for example, because she has a brain injury. And here's the power of attorney document. And so you have a conversation about healthcare issues related to mother with the attorney. But mother's down the hall. That conversation shouldn't be taking place. Mother should be in the room with you. There should be an effort on your part, and I'm sure you do this, to have that conversation with mother and to explain whatever it is you're trying to explain, and seek a response from them. Informed consent, for example. You're expected under the Substitute Decisions Act to engage them as part of the process. That again is different than a continuing power of attorney, because what continuing kicks in, it means I've got total control. I make decisions on. The hope is that you will, you know, you always do the best thing in the interest of the individual, that you try to engage the individual, but the requirement to engage the individual isn't the same. It's not there. It is in personal care. But so often, truth has it, for expeditious reasons, maybe time management, the medical profession will often turn to the attorney and keep the individual out of the equation when they're dealing with personal care. And that should not be occurring whatsoever, but it does happen. The other very important thing with personal care is it does not have the authority to restrict access to an individual. And again, I don't know if you experience that. I know as police, we experience it, because sometimes we get called to an institution and being informed that the attorney, and being informed by the staff that's called us, has declared that the son John isn't allowed to see his mother because the attorney under the power of attorney for personal care says so. That's actually illegal. And there is lawsuits that have been filed and successfully processed on behalf of the individual, the grantor, that says you can't do that. You don't have that authority. And the way the rules are, only the person themselves, mom, can say that I don't want to see my son Johnny. Unless you can provide a direct nexus between their an issue related to their overall safety, i.e. Johnny shows up every time and, you know, unfortunately batters his mother. Of course, that's another issue altogether, but her health spikes, and all of a sudden, every time he shows up, we have to call the EMS to respond to deal with the medical incident. Then that might be justification. But just to say that I don't want my brother to see my mom, and then staff supporting that, is very dangerous for the organization as it is for the staff members. So I hope that makes sense as well. But those are two big areas that have been expressed to me, and I've actually seen it in policing, that are problematic. One, people believe it's continuous, it's not. And we'll often leave people out of the conversation. The individual they're talking about, the grantor, shouldn't be incurring. The second is their perceived authority that they have and they do not have, and institutions supporting that belief, when in reality, there's nothing there. Putting both the individual who made the demand and the organization at risk of being liable through civil process. Any questions on that? Hopefully that makes some sense. Okay, so if you want, I was going to break it down for some in the sense of, and it's titled here, continue power of attorney for property, but the thought process I was just about to walk through is the idea would be that if somebody was to come to you and ask for some insight, of course, you're not going to provide them with advice, but you give them some thoughts or clarity of mind based on things. So what I'm going to do is I'm going to jump past this. I'll show you what the document often looks like. So it'll look very, this is a common one. It's a Dye and Dunham. It says up in the right-hand corner. Dye and Dunham is just a legal form producer. And it's, of course, you see the title, Continuing Power of Attorney for Property. Not sure why short form always shows up there. There's no long form. So it doesn't make a lot of sense. But if it was the power of attorney for personal care, that's what the title should say. But a few things, again, from your perspective in your interaction with your clients, and they're seeking, well, you know, what does this mean, or what kind of things should I be thinking of? I'd like to give you a little insight that maybe you can share with them. So first up, if you would look in here, of course, it's the grantor. And you know, under Substitute Decisions Act, the person the document is about is the grantor. So that would be your first thing. Let's see if I can get a little bit of a highlight going on here. So right in here. Oh, so sorry. I don't know what happened there. But right there where the grantor. So this is where their full legal name would be. The easiest way to think of that is, what is the name on your birth certificate? And the only exception to that would be is if they've changed their name legally, i.e. possibly to marriage, or they've gone and changed their name. But otherwise, the easiest way to look at it, what's on your birth certificate? And if they go by a short form or a revision of it, or, you know, maybe they have a name that is, when they came to Canada, they shortened it, for example, you know, they still need to put the name that was on their birth certificate, whatever that is, spelled exactly as the birth certificate, by the way. And then in brackets, they can say also known as Howie. One of the big one people talk about is, do I pick one person? Do I pick two? Well, this is where you would put it. Take note of this, says I appoint, and the word and jointly. I'm going to talk about that in just a second. So for that, people go, well, do I pick one? Do I pick two? Do I pick three? Believe it or not, I actually have a power of attorney that has 5 children listed. And those amongst you that are parents, I want you to imagine trying to get 2 children to agree. Now you'd only get 5 to agree at a time when mom or dad is in a hospital and a decision needs to be made, and they're about to have a conversation, maybe in an election to see, you know, the majority rules type situation. Probably not a good idea when mom and dad are in the hospital and a decision is in a position to be made. So I caution people on going any more than 2 for that particular reason. Because the other thing I also see, and you may have seen this in your experience, is if there are 3 or more, what often will happen is 2 different groups will form. Alliances are formed, and then at the end of the day, of course, it's mom that will lose, and it becomes a democratic process. Well, this isn't democracy. This is the best interest of mom, based on the information given to you. When you're looking at one person, and that does occur in many people's lives, that they only have one person available to do it. The caution there is, are they the same person on your power of attorney for personal care as they are the one on your continuing power of attorney, i.e. they're making health decisions, relative to where you're going to live, your nutrition, your safety, et cetera, and they're also the ones controlling the funds. And then what often will happen is then that extends to, they're also the executor of the will. Well, if the temptation is there, the opportunity is also there through that single person appointment, because there's no checks and balances. You've given them carte blanche authority to make decisions on everything related to your life, and then when you're gone, to ultimately cover it up. And people will go, wow, but they're my oldest son, therefore they should have. No, that's not the reason why you don't pick them based on the child ranking. You pick them on responsibility, faith, and trustworthiness. Excuse me. The other problem, what happens when you pick only a single person is, and a lot of time people don't realize there's a lot of responsibility here. I'll take you to Donna. Donna is living her life, but she's also living Howie's life. So she has her day-to-day stressors, her day-to-day, whatever, taking care of herself as an individual, taking care of her relationship. And now she's also supporting Howie in probably every component of his life where he used to do it independently. And again, something I would suggest you would see in your world a lot. So you're putting a lot of stress on one single person. Now, in Donna's case, she lives under the same roof. Let's take this as a child who lives down the street, maybe in a different town, a few kilometers away. They're living their own life. They've got their own family to look after, their own employment commitments. They come home, drive to mom's house, make a meal for mom, feed mom, set them up for the night, then drive home, make the meal for their own children, set that up. When they go to bed, they're exhausted, only to wake up and do the whole thing all over again. That's a lot to ask of one person. And along that way, not only you're putting the stressors on them, who do they have to turn to that can help? We often forget about caregivers. I imagine in your world you don't, but I can tell you many others do. According to the Ontario Caregivers Association, there's like 3.3 million caregivers out there right now supporting their loved ones. So I often try to lean people to try to think about two. Again, I don't recommend, I just want them to think about it. And the idea there is that they would do two that have to go. So the first person would be listed here, and the second person would be listed here. Now, you will see the word jointly appears. I just have to move my screen there. Jointly appears here. The word and jointly requires that they work together. So when they're signing a document, for example, making a financial commitment for a home, long-term care residency, both signatures are required on that document. Not one, both, or it's not legal. Avoid putting in and severally. I don't like that, because what that says is they can work independently, and then you will have them going in sometimes two different directions, and that's not what you want. So I always suggest personally, if it's possible, A and B work jointly. And jointly mean that they must work together, always with the best intentions of the individual involved. Does that make sense? I hope that gives some people some thought process. And again, you can extract this information from power of attorney document as you can for a last will and testament. Two executors, less chance of temptation, better chance of things being done appropriately. Others know about it. There's no hiding going on here. It reduces the stress level by carrying the weight with others. The other nice thing that it does, I want you to imagine, and again, something I'm sure you're exposed to, is that you will have a caregiver, the attorney, they do all the hard work, helping that individual, making all the best decisions that they can with all the resources and insight that they have. And I want you to imagine now that the time has come and the individual is no longer with us and they're at the wake. And I can tell you this from experiences that I've had, where somebody walks up and says, well, you stole $20 from Mom. I'm being ridiculous in the amount, but you stole money from Mom. Now you have a single person who has done so much for that person while they were with us. And they're grieving just like everybody else, maybe harder because they've had that close relationship. And out of the blue comes this accusation. And as we all know, the court of public opinion sometimes can be more devastating than the actual courts, because if it's thrown out there without proof, without substance, without, shall I say, trial, and then it sticks. If you have two people with checks and balances in place, it reduces that possibility, because when the accusation is tossed, they can come back and say, well, first of all, I did nothing on my own. Everything's recorded. It requires the two of us, et cetera, et cetera. So another benefit to having two people. The other thing, next part of that is, and it's so very important, folks, going back to the question that came out earlier from the lady from Sudbury, and I apologize, I forget her first name, but how good am I, how long do my documents last? Well, they last until such time as you either revoke them or produce a new one or you pass. So I want you to imagine, though, you have done it 8 years ago. And the person, one of these individuals who you appointed is no longer capable. They have physically moved away from Sudbury. They're now living in Ottawa. Is it realistic for them to help make decisions in healthcare living so far away? Probably not. Or maybe they too have capacity issues. Maybe their life has changed in such a way that they can't carry on additional burden, responsibilities. Maybe they've passed. And if you, again, only have one person, your document is no longer valid because the individual is not there to help you. So you kind of defeated the purpose. So you always want to be thinking two down. And what I mean by that, again, is something happens to the first person appointed, who have I put in substitute? That holds true too in your will. Two. That holds also in your will when you're looking at the executor X appointment, but also the benefactors. Think about when you write your will, if I were to leave something to my spouse, well, what if the spouse predeceases me? Or just an aside for you, I want you to imagine one day that you're out together, children are home, and it just turns into a bad day all around. And you're both no longer with us. Now what happens? Well, if your sole benefactor was your spouse and your spouse is gone with you on the new journey, you didn't really have a will, because there's nobody to leave anything to. So at the end of the day, intestate would kick in and all the issues regarding that, passing without a will. So it's always important to think two down, from a substitute appointment as well as a benefactor appointment. And what I suggest to people here is, I want you to imagine for a second and see if I can actually, make this work. So let's imagine for a second, I put up in here, Jane. So Jane is, whoops, I don't know if you can see that, hopefully you can. And for the purposes of my second person, Jane and Mark. So Jane and Mark must work together jointly to make decisions. And again, this holds true for personal care as it does for property. So under the substitute category, Okay, I would now, if I can get my pointer back. Under substitute, what I've said is Sue, San, and Mark. And I would say, in the event that something happened to Jane, I appoint Suzanne and Mark. Or in the event that something happened to Mark, I substitute Jane and Suzanne. And the reason I'm doing that is because I always want two people to be in the position of making decisions for me. I don't have to do that. If something happened to Jane, then automatically the document's still valid. It would just revert to Mark. But for all those reasons I've explained about the value of having two, it would, now you're putting all the pressure, responsibility, etc. on Mark. Whereas you may be looking to share that. I hope that makes sense to people. And I can see an opportunity in your, where you work and your involvement with your clients that, they come forward and, I don't know who best to pick. The other thing, if you're talking to them and they're asking you for some suggestions, express upon them the importance of never surprising people. And that's occurred. And I've had situations where people go, I was appointed and I didn't even know about it. Not good. So the individual should be having a conversation with someone and saying, in the event that I have issues, my personal care, would you be prepared to help me? And if they find that that individual, the son, the daughter, the friend, the neighbor, whatever, turns to them and says, you know what, I don't think I could. I don't think I could do what you're asking me to do. Then that individual shouldn't put pressure on them to do it. They should be very, very happy with the fact that they just did them a huge favor. They were straight up honest with them. And they've told them, what, I can't do this. Please go find someone else. And that would be then the opportunity for the individual to go seek someone else. If you have a client that sits back and goes, I can't think of anyone, there are lawyers that will take on what's called the trustee status, but they would need to seek out that lawyer. And remember that when the time comes, that lawyer would most likely be paid for the services. So as long as they know that up front. But the key thing is, as alone they may feel, in reality, they're not. Because the system is there that would set itself into motion, that would give them somebody. Yes, it's a stranger, but even that sometimes is a good thing, because it's a stranger who has professional responsibilities and accountability for their actions. So hopefully the decisions they're making are truly in line with your wishes, legal, accountable, and all those other things. So sometimes, picking that person might even be the better way to go, as opposed to picking that family member who, when it comes time to making a decision on what to have for lunch, waffles. You need a medical decision right away. This is not the time to be waffling. Excuse, I guess, the use of the term waffle at lunchtime, eh? So now if I can get my mouse to, oh, so sorry. There we go. I don't want to take my mouse back. But anyway, does that make sense to anybody, to everybody? Any questions on that? For your personal world, when you're doing these documents, as well as your clients, it's always suggest to consider that. Just imagine the impact on the individual you're asking to do this. And so if you can lighten, I'll use the word burden. It shouldn't be a burden, but it could be. You lighten that by doing, by picking more than one, but don't pick too many because then it becomes a real mess. So let me take that away. Any questions at all? Any comments?
Yeah.
Okay. Why have I not got control back? Okay, let's see if I can get this going. All right. Remember, if they're using more than one person, the word and jointly should be used, not the word severally. And try to avoid that word because that means they can work independently. What else things? The wonderful world of capacity. So what you'll find, if people are using the standard forms, whether they're taking it off the internet site from the Attorney General's office, or whether they're taking it from a lawyer's and they're using this particular form, regardless of whether they look very similar. It just says the title usually changes, power of attorney for personal care versus continuing power of attorney for property. Paragraph 3 is generally that where the whole issue of when it comes into play. In this particular form, it's actually it's the 4th paragraph when you add the paragraph numbers up, or just not the numberings there. And what it says is when I am not capable, and it'll say for personal care, managing concerns of my personal care in accordance with the Substitute Decisions Act 41, or in accordance for property when I'm not able to manage my property pursuant to Section 7 of the Substitute Decisions Act. What that actually means, if you would look up Section 7 of Substitute Decision, that triggers the capacity assessment. A lot of times, though, people don't do that. They just come say, hey, you know, my mom's got brain injury or dementia, and therefore I'm here to speak on their behalf. As an organization, you should be actually questioning, where's your authority to trigger this document? So provide me some proof. Hopefully, one day we get this changed, that they will be requirement by law, but it is not right now to provide that. Although the document that I produced, that I as a grantor have said, the only time I want you to act upon this is when the Substitute Decision Act rules are followed and I've been deemed incapable. That means triggering a capacity assessment. Now, if you're not aware, there are 9 different capacity assessment potentially. One is for the management of your property. There are 6 potential tests with respect to the matters of healthcare, personal care, sorry. And I always have problems. Remember, I think of 5, but anyway, let's see if I can remember them. Healthcare, safety, nutrition, clothing, hygiene, and I always forget number 6. Oh, shelter. So you can be tested for each of those independently, and it is not a problem. But remember, if you have a client and the document says, in my opinion, Mrs. Jones does not have the capacity to make decisions with respect to her shelter, you can't extrapolate that to mean to equal she can't make decisions with respect to her health care. It only speaks to shelter. So heads up on that one. And a lot of people don't realize that, because a capacity assessment is not covered in the healthcare system. So it's a fee for service, anywhere from $500 to $3,000 per test, depending on who they hire. With the average right now, I understand about $850. So a lot of people don't realize they're actually triggering something where they are responsible to pay. And then that brings in a whole bunch of different things. Does that make sense to everybody? Any concerns on that particular issue? So this is what I like to have a little fun with. I'm going to jump up here. You know, we all have bad days, right? Does a coffee solve that one? Maybe not. But if you're looking at the word capable, because that's what the document's using, right? It's using that word incapable. By definition, which I always love under Substitute Decisions Act, the word incapable means mentally incapable. Now, if you take yourself back to the days of school and in English class, and you were asked to define a word, you know, Ruth, I need you to tell me what the word tomorrow means. Well, tomorrow's, you know, it's the day after tomorrow, you know, or you start in the, you put the word in your definition. The teacher jumped all over saying you can't do that. And then you'd sit there and go, well, tomorrow, that's the day preceding today. Yes, thank you. Well done, Ruth. We'll give you a start today. And you said, well, the government just did it. Incapable means mentally incapable. Huh? What they're saying there, folks, is they're not defining the line in the sand of capacity versus incapacity. What they're saying, though, is under the Substitute Decisions Act, when they make reference to the word incapable, it is strictly mentally incapable. So it's not a physical issue, it's a mental issue, which of course is going to be, I would imagine, the majority of your patients or clients. It's very key to understand. So when you walk that through, it makes sense, but initially it doesn't. So there's a difference in the world of capacities, but I'm sure you're quite familiar with the whole informed consent concept. Being healthcare professionals, and again, if just to recap, is informed consent being that you're presented with a situation, you're given the information related to it, no holdbacks, and you, based on that information, given an opportunity to make a decision as to direction. And if you have the capacity, you're able to make that decision or a decision and give direction to the healthcare, awesome. Conversely, you're given all this information and you choose not to make a decision. And so, for example, Mrs. Jones, I'm sorry to say that the nature of your situation requires that you try this new experimental drug, and here's the side effects, yada, yada, yada. Or conversely, we have an operation, and anytime we have an operation, of course, the fear here is, or the risk to you is that the anesthesia causes you problems, could lead to death. Mrs. Jones, I need you to make a decision. And Mrs. Jones goes, well, you know, I understand, thank you very much, healthcare professional, but I choose not to do either one of those. As long as they realize the ramifications of that decision, everyone's fine. And I'm sure you folks experience that all the time. It's informed consent, right? And it's a very, very applicable, not only from personal care perspective, believe it or not, it's also applicable under property. Big in your world, of course. So when we look at capacity, there's two different things, and they often get confused because people will bring in the medical capacity and try to apply it from a legal perspective onto what is more of a testamentary capacity. So medical capacity is exactly that, informed consent. So when it comes to dealing in the healthcare world, as long as it's formed, you've got consent based on informed, or conversely, they don't make a decision, but they're fully aware of the implications of failing to make a decision. Everything's good. Testimonial capacity, folks, is on a higher point on the scale. It is considered to be the best time for clarity of mind. And this is if you would go to get your documents done before a lawyer, they have to actually assess you in some form. There is no standard so that they are comfortable with your testamentary capacity, so that if they were to be challenged later to prove that you had the testamentary capacity to enter into a POA or a last will and testament. And that's why I was saying at the beginning, where I could see some potential concerns here with your clients. If they've been identified as having a brain injury, does that distract from the testamentary capacity? And I will suggest to you that there's the potential for it. One solution might be that the medical professional that they're using, the psychiatrist, for example, write a document to say that this person is capable, according to my professional knowledge, to enter into legal documentation. The other would be triggering a capacity assessment. And as I told you, there was 9 categories. Well, there are 2 categories related to the capacity to enter into power of attorney and I will, and the ability to withdraw from them. There's one for each. So the test that might be conducted here would be, of course, done before they went to see the lawyer and finalize the documents, just to ensure that the lawyer now has documentary evidence and can feel comfortable that the individual sitting before them who has a brain injury has the testimonial capacity, or they have confidence in their testimonial capacity to give direction and then ultimately produce these documents. Does that make sense to people? Just remember that you can't carry one automatically into another. And in your world, because their brain injury stigma could cause problems. That's one way around it. I hope that makes sense. So just in case you're not sure of, this is kind of where I put this. I call it the scale of capacity. I'm taking you back maybe a few years in life, but you might have had a day like this. The Pink Panther's having a rough go right now. Thank goodness for his park bench. And he'll sleep it off. And right now, at his stage, probably not a good idea to make decisions with respect to his health care. Would probably most likely won't be very informed. And then for those that are married in the group right now, when it came time for you to marry, the person presiding over your marriage only had to prove that you weren't intoxicated or under the influence of drug at the time that you said, I do. By the way, just an aside on that. If you had a will or your clients had a will and they have since married, they invalidate their will when they say I do. Now that law is changing in 1st of January 2022. But if they've been married up until still coming the 31st of December 2021, and they had a will in place that didn't acknowledge the marriage, then they no longer have a will. Just an aside. So again, let's go back. Poor Pink Panther, he's sleeping this off. Congratulations to you, those of you who are married, when you said you do, and that I'm confident that you weren't in the state that the poor Pink Panther was in. But if you went before a lawyer and you produced your legal document, contract, etc., you had testamentary capacity. Medical capacity, folks, can be anywhere in between this scale, because it all depends on the issue, what the medical concern is. Are you under the influence from a prescription drug to help you with your medical? Are you receiving treatment? Yada, yada, yada. And it probably fluctuates around here depending on a whole bunch of different parameters. And again, something you've seen. So if that's occurring, you may not achieve testamentary capacity. Again, potentially problematic for your clients. So any questions on that? Anybody feel like the Pink Panther today? No? Okay, I can't think of a good joke to kind of break the ice, but I know I'm coming to the end here for you. But the one thing I wanted to let you know, and you may probably already know this, again, I make it a lot of assumptions, and I apologize if my assumptions are incorrect, and do speak up if they are. Please help me to understand. But the determination of capacity, highest level would be a Superior Court of Justice. And in fact, folks, that would be if a court were to order that the person is deemed by law to be incapable. That's a long process that takes place. There are two different avenues they will travel down. First would be the management of property, and the second would be the management of personal care. The more challenging is personal care. And if you're wondering why that is, just imagine it's civil liberties. It's the taking away of your civil liberties, ultimately, which the court doesn't wish to do. So there's two challenges in there. Property generally happens much smoother and quicker. Personal care, not so. If you're looking at a person wants to challenge a capacity assessment that's being done on them, this is where they would go, being the Consent Capacity Board. You may have had experience with them. The nice thing about them, any referral to the Consent Capacity Board must be heard within 10 days of receipt. It's right in their legislation, which is really nice. The Mental Health Act generally deals with people going through a mental health situation. And so during the time that they are in the mental health connection, like a ward or something, they're covered under Mental Health Act. The moment they're let free, they're discharged, and they're no longer, and therefore their capacity is considered to be fine. So on the scale, the bottom of the scale, if you would, be the licensed capacity assessor. So often people like to add to that scale, well, the opinion of a medical doctor. And if the power of attorney for personal care doesn't, or the continuing power of attorney does not say that a medical doctor can provide opinion as to my capacity, then it's not possible. You can bring all the letters you want that says mom can't. Most doctors that write those don't realize that they're doing, but it's an opinion with a foundation of who knows what. But when it comes to the actual determination as to one's legal capacity, starts with a licensed capacity assessor. Maybe mental health comes into play, Consent Capacity Board, and then ultimately the Superior Court of Justice. Any questions on that? Any concerns? Doctor's notes, so often, it's amazing how many people will act off a doctor's note. Remember, the doctor's note is an opinion. And of course, our opinion of someone else doesn't count either. So the last part I wanted to bring up to you folks, again, from your world, was the substitute decision maker. I'm sure you've heard this, SDM. It is intended when the individual's in a healthcare facility, by the way, doesn't by extension go into long-term care, and doesn't by extension go into retirement homes. So it's the hospital. The top of the list is the guardian. At the bottom of the list, if you would, is Office of Public, the guardian and trustee. And the hope is that they never get to number 9. Someone in between. I've actually seen it, the power of attorney document, because they appointed a complete stranger, the child of the parent in this case, wasn't even allowed to be in the room to be part of that discussion on how the health was going to be, the actions that the doctors were going to take in support of the parent for health, which is very, very sad. But the substitute decision maker, SDM, covers people for healthcare only. So if you have a client come into, do I really need a power of attorney for personal care? again, not giving them advice, but you might want to provide some clarity in the sense that in the event that you have a health issue, then the substitute decision maker under the Healthcare Consent Act is going to cover you. You're going to be safe, provided, of course, it's your wishes are you want them to do everything they can to keep you alive and going well. If your decisions or something or wishes are something other than that, then you need a power of attorney for personal care. The other thing, though, is that is strictly one component of the 6 categories of personal care. So the question that you might then want to present back to them, and they will probably get the answer themselves, which is what you want, is that remember, you've covered off one component under the Healthcare Consent Act, healthcare. What if decisions have to be made about where best for you to live? Your nutrition, your clothing, your safety. And if they go, well, and as soon as they do the well, then that's where you might want to suggest that that's the purpose behind the power of attorney for personal care. That covers on the of those categories that are not covered elsewhere. Because if you don't have a power of attorney for personal care, who's going to make those decisions within law for you? There is nobody. So now do you have to go to public guardian trustee, become a guardian, and you have to go to courts, the family go to court, etc. So I hope that gives you a thought. And if you have clients that are looking for clarity in their document, rather than just writing, in accordance to the Substitute Decisions Act, when I'm not incapable or I'm not capable, they might want to put clarity in there. Now, this is not the best example. I took it from some paperwork that I got when I was studying at Osgood. Believe it or not, the original sentence was an entire paragraph written by a lawyer. I've kind of broke it down a little into 2 different paragraphs. But yes, it started out as a single sentence, 1 paragraph. But what it does is provides a little degree of clarity in there. It is not in any way a living will, and it is not an end of life decision, because you cannot do end of life decisions in a power of attorney for personal care. That's a total different process. It cannot be done in a power of attorney. And if somebody were to write in end of life decisions, it would probably be totally ignored. But this is one way, if they wish to do that, don't keep me alive, use mechanical devices, make my life as comfortable as possible, please, and allow me to move on slowly, peacefully. So the other thing that they may want to consider, if they're not comfortable with having this capacity assessment done on them, is this narrative. And this is one I grabbed and used myself. And you will see on the subparagraph C, I put another or in there. The intent behind that is they could have their own thing they want to put in there. But what I said was, in my personal case, if my medical doctor who knows my history, my medical history, understands the medication I'm under, understands, what I have gone through this period of time, and I can see that with your clients, for example, authorized to practice in province Ontario. Why Ontario? Because someone foreign to the province may not be properly licensed, for example, especially if you're going overseas for treatment, and it could be a challenge. They provides a written opinion, because that's what it is, their opinion, that they conclude that I'm not able to manage my property or make decisions of my personal care. So I'm providing clarity there, but I'm also saying, you know what, don't bother going through the capacity assessor. If this doctor who knows me and has experienced, the last 10 years with me giving care, who also understands not only what I'm going through, but the medications I'm on, et cetera, they've come to the realization that I don't have clarity of mind, informed consent, then I allow a note, a document from them to trigger my power of attorney document. Failing that, all right, let's use the Substitute Decisions Act, where capacity assessor will kick in, and ultimately B is just a longer way of saying C. but it just gives you an idea of how important it is to provide a little degree of clarity. Believe it or not, just the last thing, you could actually say in there, when Aunt Martha decides that I have not got capable mind, I've only seen it once. Aunt Martha decided that I'm not capable of managing my property. I don't think I personally would want Aunt Martha making decisions as to whether my capacity is sufficient to make decisions with my health, let alone the management of my property. But this particular person chose that, and that is really acceptable, by the way. With that, I hope you found this of value. Are there any questions? Crickets. The joys of Zoom. Nothing? No?
I think you did such a good job explaining everything. Maybe that's why there's no questions.
Yeah, you never know. That's the unfortunate thing. I apologize if I've missed that, but that's the problem with Zoom, is because I can't see anybody. I can't judge reactions. And if you're scratching your head, unless your camera's on, which nobody's was, I really don't know. So I hope you found this of value, folks, in 3 parts. Personally, how important it is for you to have these documents for yourself and your family. It's your opportunity to let everybody know your wishes. So next time you blow out your candles for your birthday cake, awesome. But just remember, those wishes should be expressed, not hidden. So personally, professionally, how important it is to understand what these documents look like and what the restrictions are imposed upon them. Are you working actually within the guidance that's out there? Are you extending yourself? You're denying access to the client's child to see their parent, for example, because the attorney told you to do it. Well, I wouldn't be. And then ultimately, as an organization, to protect yourself as well. So I think I just saw something come up in the chat. Oh, okay. Those are great thank yous. I appreciate that, folks. Thank you. I promise that I will send stuff up to the Ontario office, those documents that I promised. So I will send a sample general. I'll send a continuing personal care. Look closely at them. I'll send a responsibility of estate trustee, executor of a will, executor X. Let me know if there's anything else that I can send to you. I will be more than happy to do it. I've compiled a lot of things over the time frame, and I am here if I can help anybody in any way possible.
Thank you.
Ooh, I just did what I always do. This fix that.
Many thanks again, Martin. I think that you've given everybody a lot to think about regarding our clients and regarding our own, taking care of our own business. And so I just wanted to thank you. I have to step out as I'm getting on another meeting, but I just wanted to make sure and say thank you. And then I'll just leave it up to Melissa to close us out.
Thank you, Ruth. All the best to you. See you on the 1st.
Yes, will do.
Thanks, Ruth. And I echo what Ruth said on behalf of the OAC and all the members that we support. This information is so valuable. And I think we all appreciate how hard it is to do these things when you're talking to avoid, but you really did it with humor. You scared us a little bit, but it was a good scaring. But you certainly kept us engaged in this world where we're just looking at our screens all day. So thank you so much. And thanks to all the associations who attended and who will be sharing all the great information and resources.
Thank you, Melissa. And thanks to everybody out there. I really appreciate it. You guys do great work. I'm learning more and more about you every day. Your support to us as police officers. I challenge you to let them know who you are. You might get some pushback. If you do, write me. We'll see if we can break some barriers down for you, but make yourself be known, folks. You're an awesome, awesome resource, and help break that barrier of ignorance. Please. Thank you very much. May you all have a great day.
Thank you so much. Bye, everybody.